Welcome to the EPG Pathshala Criminology. I am Professor G.S. Bajpai presenting you the Supreme Court landmark judgments on victims of crime. This is part 1 and the learning objectives for this presentation include to understand the position of victim in criminal justice administration and also to learn various rights of victims in procedural justice and to study Supreme Court's judgments protecting the rights of victims to provide justice. Victims of crime pertinently form an integral part of the subject matter of criminology. But whenever there is a crime problem, intellectuals and policy makers are quick to ask what can be done to the criminals and or the circumstantial events that precipitated such criminality. Very few ever ponder over what can be done about victim and or his or her circumstances. Victim, though represented by the state in a prosecution, stands in the backdrop of and during the course of the trial as an identity in himself. The viewpoint of complainant of victim or crime, the judicial process is unimportant. After all, it is he who the law was set in motion. Even if there is a passive involvement in the trial, not ideally speaking, though his rights and needs cannot and ought not to be compromised anyhow. It was rightly observed by the Apex Court in Jahira Habibullah H. Sheikh versus State of Gujarat in 2004 that since a trial is primarily aimed at ascertaining the truth, it has to be fair to all concerned. Further, the court ascertained that it will not be correct to say that it is only the accused who must be fairly dealt with. Each one has an inbuilt right to be dealt with fairly in a criminal trial, and denial of a fair trial is as much injustice to the accused as it is to the victims and the society. The significance of victim intervention has been recognized by various ways by the Supreme Court in India in the context of different stages of the process. These includes the stages of anticipatory bail, transfer of cases, consideration of charge at the trial in the special context of vulnerable witnesses, including rape witness and victim, at the time of appearance in the court, in the matter of sentencing, which includes taking care of needs and interest of the victim, and suspension of sentence. These areas are elaborated one by one hereinafter. So, let us first look at the stage of anticipatory bail. In Adri Dharan Das versus the State of West Bengal, the Honorable Supreme Court of India was construing the extent of power and jurisdiction of court in matters of anticipatory bail under section 438 of the Criminal Procedure Code of 1973. The court in this case pointed out the need to insulate the victim and his or her kin from undue intimidation or influence as one of the prime consideration through following observation. Ordinarily, arrest is a part of the process of investigation intended to secure several purposes. It may be necessary to curtail the accused freedom in order to enable the investigation to proceed without hindrance and to protect witness and persons concerned with the victim of crime, to prevent his disappearance, to maintain law and order in the locality. For these or other reasons, arrest may become an inevitable part of the process of investigation. The legality of the proposed arrest cannot be gone into an application under 438 of the code. The role of the investigator is well determined or well defined, and the jurisdictional scope of the interference by the court in the process of investigation is limited. The court ordinarily will not interfere with the investigation of a crime or with the arrest of accused in a cognizable offence. An interim order restraining arrest, if passed while dealing with an application under section 438 of the code, will amount to interference in the investigation, which cannot at any rate be done under section 438 of the code. The above position was reiterated in Parvinder Singh versus State and Union of India versus Padam Narayan Agrawal in the year 2008. This relates to the transfer of cases under section 406 of the CRPC in CBI versus Hobson. In this case, the Honorable Supreme Court was dealing with a request under section 406 of CRPC for transfer of a case involving offence of kidnapping and murder of 3 government employees in the state of Manipur, which had been investigated by CBI. The case had invoked considerable unrest and public outcry in the state of Manipur, giving rise to apprehension of ethnic conflict and social unrest, since the alleged killers were Naga ethnicity while the victims were from Methi community. The CBI, in its application for transfer of the case to Delhi, referred to its highly emotive nature with serious possibility of ethnic clash between Methis and Naga, and expressed view that very presence of the accused in the Manipur was likely to lead serious law and order problem, breach of peace, violence and imminent threat to the life and safety of the accused. Besides the apprehension as regards the safety of the accused, CBI also highlighted the danger of witnesses being intimidated and the undue harassment of the victim's family. Honorable Court found substance in the ground about the interest of the near relatives of the deceased persons in the course of the criminal proceedings. Examining the prayer from the perspective of what is expedient in the ends of justice, the court recalled the following observations made in Manika Sanjay Gandhi versus Rani Jethmalani, that the safety of the persons of an accused or complainant is essential conditions for participation in the trial, where that is put in peril by commotion, tumult or threat or on account of pathological conditions prevalent in a particular venue. The request for a transfer may not be dismissed summarily. The court thus ordered in the Hobson case the transfer of the case to Delhi in order to ensure that a fair trial takes place so as to account for the interest of all stakeholders, namely the accused and the witnesses and the prosecutors, the near relatives of the victim, as well as the society at large. It was further directed that the CBI as well as the government of Manipur shall render full assistance to the victims' legal heirs in the matter of legal representations by way of engaging advocates of their choice, and arrangements be made for to and fro journey and stay, etc., for one member belonging to the families of each of the deceased persons on the dates of hearing. Now let us turn to the cases relating at the stage of charge. The Supreme Court was examining in case of R.S. Mishra versus the state of Orissa, the procedure to be followed by the criminal court at this stage under section 227 to 228 under CRPC of consideration of the matter on record to find out in a case was made out the accused to be put to trial, that is, as to whether charges deserve to be framed, or in the converse, if the accused was entitled to discharge. It was in this context that the court observed as under. It is also to be noted that a discharge order is passed on an application by the accused on which the accused and the prosecution are heard. At the stage of discharging an accused or framing of the charge, the victim does not participate in the proceedings. While framing the charge, the rights of the victims are also to be taken care of, as also that of the accused. That responsibility lies on the shoulders of the judge. Therefore, on the analogy of a discharge order, the judge must give his reasons, and also needed is that order should inform the prosecution as to what went wrong with the investigation. Besides, if the matter is carried out to the higher court, it will be able to know as to why a charge was dropped or diluted. Now, let us look at the cases relevant at the trial stage. At trial, against the backdrop of the Gujarat riots in 2002, the court in case of Jahira Habibullah Sheikh versus State of Gujarat made the following key observations on victim justice in the light of concept of fair trial. Delicate judicial balancing of competing interest in a criminal trial, the interest of the accused and the public, to a great extent that of the victim, have to be weighed, not losing sight the public interest involved in the prosecution of persons who commit offences. Further, the concept of fair trial entails familiar triangulation of interest of the accused, the victim and the society, and it is the community that acts through the state and the prosecuting agencies. Broader public and societal interest require that the victims of crime who are not ordinarily parties to the prosecution and the interest of the state represented by their prosecution agencies do not suffer even in slow process, but invisibly and irritably, which if allowed would undermine and destroy public confidence in the administration of justice, which may ultimately pave way for anarchy, oppression and injustice, resulting in complete breakdown and collapse of the edifice of the rule of law, enshrined and jealously guarded and protected by the Constitution. Legislative measures to emphasize prohibition against tampering with witnesses, victim or informant have become the imminent and inevitable need of the day. Let us look at now vulnerable witnesses, including rape victims, in court. The issues concerning need for protection and care for vulnerable witnesses, particularly those who are victims of sexual offences at the time of appearance in court, came up in case of State of Punjab versus Gurmeet Singh in 1996, where Honorable Supreme Court took note of how these sexual assaults take toll on the human dignity of the victim, and merely not violating the victim's privacy, personal identity, but inevitably causing serious psychological as well as physical harm in the process. Rape being not merely a physical assault, but often destructive of the whole personality of the victim. The court lamented at how the treatment of the victims of sexual assault in the court during their cross-examination leads to further harassment and humiliation, with the presiding judge sitting as silent spectator, turning the judicial process a traumatic experience. The deposition in court, particularly the cross-examination, compelling her to repeat again and again in unfamiliar surroundings what she had been subjected to, even while she may be too ashamed and even nervous or confused to speak, and her silence or a confused stray silence, often wrongly interpreted as discrepancies and contradictions in her evidence. The court noted the amendments incorporated in the statutory provisions through Criminal Law Amendment Act of 1983, whereby section 375 and 376 were strengthened, besides clauses for raising presumption about absence of consent in section 114A Evidence Act of participant or particular interest. Here the amendment section 327 of the Code of Criminal Procedure, wherein subsection 2 and 3 now provide as under 327, court to be open notwithstanding anything contained in subsection A, the inquiry into and trial of rape or an offence under section 376, 376A, 376B, 376C, 376D of the Indian Penal Code shall be conducted in camera, provided that the presiding judge may, if he thinks fit or on an application made by either of the parties, allow any particular person to have access to or be or remain in the room or the building used by the court. 3. Where any proceedings are held under subsection 2, it shall not be lawful for any person to print or publish any matter in relation to any such proceedings except with the previous permission of the court. The Supreme Court observed that the trial courts either are not conscious of the amendment or do not realize its importance, for hardly does one come across a case where the inquiry and the trial of a rape case has been conducted by the court in camera. It rules as under: the court are obliged to act in furtherance of the intention expressed by the legislature and not to ignore its mandate, and it must invariably take recourse to the provisions under section 327 of CRPC and hold the trial of rape case in camera. It would enable the victim of crime to be a little comfortable and answer the questions with a greater case not too familiar surrounding. The trial in camera would not only be in keeping with the self-respect of the victim of crime and in tune with legislative intent, but is also likely to improve the quality of the evidence of a prosecutrix, because she would not be so hesitant or bashful to depose frankly as she may be in an open court under the gaze of public. This would save any further embarrassment being caused to the victim of sex crime wherever possible. It may also be worth considering whether it would not be more desirable that the case of sexual assaults on females are tried by lady judges. The court should, as far as possible, avoid disclosing the names of prosecutrix in their orders to save further embarrassment to the victim of sex crime. the anonymity of the victim of crime must be maintained as far as possible throughout. Trial of rape case in camera should be the rule and open trial in such cases be exception. The judgment of Supreme Court in the case of Sakshi versus Union of India in 2004 took the law to a new level. Continued concern for saving and protecting the victims of sexual offense, including children, from indignity, help the name of cross-examination, and to further directives. The Supreme Court noted that the requirement of law to collect evidence in trial in the presence of accused under section 273 and the obligation to hold trials of sexual offense in camera under section 327, and observed that the whole inquiry before a court being to elicit truth, it is absolutely necessary that the victim or the witnesses are able to depose about the entire incident in a free atmosphere without any embarrassment, nothing that the mere sight or the accused may induce an element of extreme fear in the mind of the victim or the witnesses, or can put them in a state of shock, and the reality that often the question put in cross examination are purposely designed to embarrass or confuse the victim of rape and child abuse. The objective being that out of the feeling or shame or embarrassment, the victim may not speak out or give details of certain acts committed by the accused. Thus, the court, in order to bring the procedure on an even keel for both the accused and the victim, gave the following direction to be followed. Added in Gurmeet Singh, the requirement of in-camera trial shall apply to all cases of sexual offences, including 354 and 377 IPC. In holding trial of child sexual abuse or rape, screen or some such arrangement may be made where the victim or witnesses who may be equally vulnerable like the victim do not see the body or face of the accused. The question put to cross examination on behalf of the accused, insofar as they relate directly to the incident, should be given in writing to the presiding officer of the court, who may put them to the victim or witnesses in language which is clear and is not embarrassing to the victim or to the child abuse victim while giving testimony in court, should not be allowed sufficient break as and when required. Now, let us come to the sentencing part. Recorded history would show that the restitution was a sanction almost universally preferred over retribution in ancient times. In Harvard Law Review of 1984, which published an article on victim restitution in criminal law process, a procedural analysis sums up the historical perspective on the concept of restitution in these words: far from being a novel approach to sentencing, restitution has been employed as a punitive sanction throughout the history. The primary purpose of such restitution was not to compensate the victim, but to protect the offender from violent retaliation by the victim or the community. But in the present times, the law has undergone substantial changes. Also, its purposes, as observed by the Honorable Supreme Court of India in Ankush Shivaji Gaikwad versus State of Maharashtra, the inherent distinction between civil and criminal law, in which civil law provides for remedies to award compensation for private wrongs, and the criminal law takes care of punishing the wrongdoer. The legal position until very recent continued to be the one where compensation awarding was not dominant, was not the domain of the criminal law. This conventional position has undergone a notable sea change as societies world over have increasingly felt that the victims of crime were being neglected by the legislature and the courts alike. Legislations have therefore been introduced in many countries including Canada, Australia, England, New Zealand, Northern Ireland, and in certain states of the United States of America, providing for restitution, reparation by courts administering criminal justice. The Code of Criminal Procedure of 1973 provides under section 357 that wherein compensation can be awarded irrespective of whether the offense is punishable with fine, and fine is not actually imposed, but such compensation can be ordered only if the accused is convicted. The intent being that the compensation should be payable for any loss or injury, whether physical or pecuniary. The court shall have due regard to the nature of injury, the manner of inflicting the same, the capacity of the accused to pay, and other relevant factors. The capacity of the accused to pay cannot be ignored, since any disconnect between the same and the ordered amount might render the order non-executable, and the grant of payment would remain only paper only. Thus, it is discernible from a long line of the judicial pronouncements of the Supreme Court of India that there has been a paradigm shift in the approach towards victims of crime who were held entitled to reparation, restitution, or compensation for loss or injury suffered by them. This shift from retribution to restitution began in the mid 1960s and gained momentum in the decades that followed. The Law Commission of India, in its 152 and 154 reports in 1994 and 1996 respectively, made detailed review of criminal law. The 154th report of Law Commission on CRPC devoted an entire chapter to victimology, in which the growing emphasis on victims' right in criminal trial was discussed threadbare. It was acknowledged that the needs and the rights of victims of crime should receive priority attention in the total response to the crime. One recognized method of protection of victim is compensation to victims of crime. The compensation should not be limited only to the fine, penalties, and the forfeiture realized. The state should accept the principle of providing assistance to victims out of its own funds. In the wake of these recommendations, the amendments to the CRPC brought about in the year 2008 focused heavily on the rights of victims in a criminal trial, particularly in trials relating to sexual offences. Though section 357 remained unchanged, new section 357A was introduced, under which the court is empowered to direct the state to pay compensation to the victims in such cases where the compensation awarded under 357 is not adequate for such rehabilitation, or where the case ends in acquittal or discharge and victims has to be rehabilitated. Under this provision, even if the accused is not tried, but the victim needs to be rehabilitated, the victim may request the state or district legal service authority to award him or her compensation. The case of K. A. Abbas versus Sabu brought forth the ruling that the court can also impose a default sentence on default of payment of compensation under subsection 3 of the section 357 as had been earlier held in Hari Singh versus Sukhbir and in Balraj versus the state of UP and Suganti Suresh Kumar versus Jagdish and many other cases where Supreme Court year after year it was concluded that instead of sending accused behind bars, directing the accused to pay an amount of compensation to the victims or affected party can ensure delivery of total justice. Therefore, this grant of compensation is sometimes in lieu of sending a person behind bars or in addition to a heavy light sentence of imprisonment. Not imposing a sentence of imprisonment would mean allowing the accused to get away without paying the compensation, and imposing another fine would be impractical, as it would mean imposing a fine upon another fine, and therefore would not ensure proper enforcement of the order of compensation. In the case of Ankush Shivaji Gaikwad versus the state of Maharashtra in 2013, the Supreme Court held, while the award of refusal of compensation in a particular case may be within the court's discretion, there exists mandatory duty on the court to apply its mind to the question in every criminal case. Another case that deserves attention is one where, while referring to the Bachan Singh versus the state of Punjab, the court has observed in the context of death penalty for murder case, while reformation of criminal is only one side of the picture, rehabilitation of the victim and granting relief from the tortures and sufferings which are caused to them as a result of the offences committed by the criminals is a factor which seems to have been completely overlooked while defending the case of criminals for abolishing deterrent sentence. If a person commits a criminal offence and punishment has been given to him by a procedure established by law which is free and fair, and where the accused has been fully heard, no question of violation of Article 21 arises when the question of punishment is being considered. It seems to me that while considering the problem of penology, we should not overlook the plight of victimology and the sufferings of the people who die, suffer, are maimed at the hands of criminals. In the conclusion, we can say the apex court has left no stone unturned in the endeavor of making the victim not just comfortable but also proactive. His case and the cause of justice demand his involvement much without hesitation and unwanted fears. Strengthening the victim through the above articulated positive changes can make the victim self-sufficient and ensure that he stands remedied at every stage. The apex court has only progressively softened the law's approach in handling the genuine victim. Once a person becomes a victim of criminal wrath, the civil society cannot afford a double victimization during the legal process. The victim assistance is the common thread among all these pronouncements, a term wide enough in spirit and ambit to cover needs of protection, compensation, restitution, participation, et al. Thank you.